Good afternoon, everybody. We're going to go ahead and get it started with the session. There are still some people jumping on, which is just fine. My name is Terry Hecker. I'm the Wellness and Benefits Consultant for the Medical College, and I'm happy you were able to join us this afternoon. This afternoon, we're going to talk about estate planning. Obviously, estate planning can be quite complicated, but we hope to help you this afternoon get a plan in place or get information to get a plan in place to help guide you with the best things to do when you're going to leave people your money after you pass away. So we have Jim Guckenberg with us from Halling and Cayo law firm, which is located right near downtown in Milwaukee. And we also have Mark Lash, who's the senior benefits consultant. He and Celeste Miller, who's also with us this afternoon. She is a benefits consultant. They manage most of the retirement plan. You've probably dealt with them before. So I am going to kick us off and get us started right away here so we can dive into the estate planning presentation. So I'm going to turn it over to Jim and we'll get started. Give us just one moment. And I would like also to notify you of just some housekeeping items. If you can put your questions in the Q&A, we'd appreciate that. We will provide some time for questions at the end. May sprinkle a few in if there's good points to stop. But please put your questions in the Q&A, and you are muted upon entry. So we won't be able to hear you if you ask questions. And with that, Jim, go ahead and take it away.
All right, thank you, Terry, and thank you to everybody who's attending today. Very happy to be here. I think I was here a couple of years ago, and it was a great experience. So I'm really pleased to get back. Just to get us started, hopefully you received a packet from Terry. You should have received an email with a couple of things, a little bit of information about our firm, but more importantly, a worksheet that you can use to kind of follow along with the session and just kind of fill in some information, take notes on, and then also what we call an estate planning workbook. We'll talk a little bit more about that at the end. But if you haven't gotten those out now or haven't accessed them, now's a good time to do that. Just to get us going, as Terry said, I'm an attorney. So of course I couldn't start any presentation without giving some sort of a disclaimer, right? It's very important that we always do that wherever we go as lawyers. So just for the disclaimer part of it, everything here is for informational purposes only. There's no intention to provide specific legal advice to anybody's specific information or create any sort of attorney-client relationship. Obviously, when you have an attorney-client relationship, there's some confidentiality protections that go along with that. And we wouldn't want anybody waiving those kinds of things. So toward the end, there'll be an opportunity to ask some questions. I guess there'll be a chance to put them in the chat or the question box throughout. And the tie-in with the attorney-client relationship is, well, we won't get into answering anything specific, but we'll stay more generalized, answers to questions that apply to everybody. So just be aware of that. So now that we've got that out of the way, let's move on sort of to the heart of the matter. And with any estate planning seminar, I think the most important thing, or the first question to ask, is what exactly is an estate plan? And the title of this seminar is Estate Planning Basics. And so probably one of the most basic questions that you can ask in a seminar like this is, what exactly do we mean when we talk about an estate plan or estate planning? And so with estate planning or an estate plan, I have a little definition here for you. There's no one right definition, but essentially it's a plan for what happens to you, your person, your property, and if you have minor children, your minor children, in the event that you either die or become incapacitated. And you'll see throughout the presentation that there's sort of two, not opposing forces, but two forces going on. One is the situation where you've actually passed away or your spouse has passed away. And the other is the situation where you're still alive, but you're incapacitated in the sense that you're not able to make decisions for yourself. And so those two things will sort of be going back and forth here, and it's important to, as best you can, kind of try to keep those two concepts separated for yourself, even though there'll be some overlap. The best way that I have found, at least the most comfortable way for me, in a way that always works for my clients, to talk about estate planning, is to talk about, first off, what happens when someone dies or becomes incapacitated without an estate plan. In other words, what happens if you do nothing whatsoever? Once you have a groundwork about that process and procedure, then the things you can do with estate planning to either encourage or try to avoid those things make a lot more sense. So let's talk about sort of what happens if you die or become incapacitated without doing any planning. So there's the big word that everybody's heard of, or many of us have heard of, probate, right? If you don't do any sort of estate planning and you die, or very often when you become incapacitated, your family will come into contact with the probate court. And a probate is there's a probate court system. Every county in the state of Wisconsin has it. It's its own separate court system that deals with deceased estates of people who have died, or deals with what to do with folks who are incapacitated. And so, more specifically, probate is a court proceeding used to transfer title to property owned by someone who has died. And like I said, it's its own court system. A probate case takes anywhere from 6 months to years. I can tell you that when a probate case comes into the probate court, they immediately calendar out a date 18 months out to check and see what's happening and make sure that the case is moving along, and they expect hopefully by that time you resolve things. But it is a lengthy procedure. For the most part, it requires at least some court appearance, not always, but very often it does. And like I say, there are a number of specific procedures and deadlines and tasks that have to be done. It's really about a court overseeing disposition of your assets so that they are disposed of either according to your will or according to what the law says in terms of who your heirs are. I mean, that's really what it's about. It's about identifying property, collecting it, paying your last bills, and distributing. For most of us, it's something that we try to avoid once we hear about it. It's not something that's real pleasant for a family to go through, and it costs money. And a probate that's real straightforward can cost anywhere from maybe $3,500 to $5,000 that'll get paid out of your estate to handle that, and it can get significantly more expensive if complications arise. So that's probate, and that's transferring title to property if you die. The other part of that we alluded to is guardianship. And for adults, guardianship happens through the probate court system. Guardianship deals with situations where you are incapacitated. And I've defined it here as a court proceeding that removes certain rights from a person who's alive, but is not competent to make decisions for themselves, or it appoints someone to make decisions for a minor child. And so this is the situation where you are incapacitated, but you can't handle your affairs on your own. The court has the ability to remove your right to make decisions, whether it's financial or healthcare decisions, and it can do it in varying degrees, and grants someone the authority to speak for you. Guardianship is a little bit different in terms of timing with probate court. The law says that a guardianship really has to be done within 90 days of the date that the court receives a petition asking for a guardian to be appointed. So it's a much faster procedure. But I like to tell people, having done both probates and guardianship cases, a guardianship is shorter, but it's all the same amount of work, just compacted into a shorter period of time. And therefore, it's pretty close to the same in terms of costs for your family. So that's the procedure in terms of probate and guardianship if you pass away or become incapacitated, and you haven't done any estate planning whatsoever. So for many people, they look to avoid these because they don't like the idea of their family members having to go in through a court proceeding. They don't like the time it involves to follow through with these kinds of proceedings, and they don't love hearing about the costs. So we're going to talk about sort of what do you do to avoid guardianship and probate court. But before we do that, we should just pause here for a word about wills. For many people, their last will and testament is what they think about as their estate plan. When I have people call me and they want to talk about estate planning, I'd say half the time they don't use the word estate planning, right? They use the specific document. And most of the time it's, I want to talk to an attorney about a will. That's how, just in our culture, we sort of define estate planning for many of us. The thing to know about wills that not many people know is that a will is really only a document that's ever used in a probate court setting. If you go to if you die and your family goes to a bank and they say, here's my parents' will, it says I'm supposed to get the funds from their bank account. Or you go to sell your house and they say, well, it says right here in the will that I'm supposed to sell it. I'm authorized to sell it, and then I get the money for it. Banks, real estate agents, title companies, financial institutions, none of them rely on wills. A will is a document that a court uses in a probate setting to interpret what your last wishes are and determine, make sure that those wishes are carried out appropriately. So if you think of the phrase last will and testament, right? Will being your desire, what are your last wishes, right? And testament coming from or related to testifying, right? As in testifying in court under oath. And for a will to be enforceable, it has to have one of two things happen. Either it has to be a sworn document that's sworn and notarized at the time you sign it, right? Or others who know that you made this will and were present when you made it and signed it have to testify saying, yes, I know that so-and-so, person A, Bob, Gladys, Alice, whoever it is that made that will, I was there when she signed that document. Those were her intentions. I can swear to that. And so when you come with last will and testament, it's a sworn document that sets forth what your last wishes were. You're deceased, so you can't be there in front of the court. The court can rely on this document that you created to tell it what it ought to do with your assets, whether it's to give it to your children or your spouse, or other relatives or friends, or a charity, wherever you want those assets to go. The court will see that that happens once it follows through all the statutory procedures. So wills are not usually what everybody thinks that they are. So what can we do to try to avoid probate and guardianship? What are some of the estate planning tools available to try to avoid probate and guardianship? So we're going to go through now a laundry list of them. Most of them you'll find around this worksheet. There's a few that I've added since that worksheet was made that aren't quite there, but we'll talk about them and you can make note of them. Some of them are going to be not maybe what you think of. So one of the main tools that we use is a power of attorney. And a power of attorney is a document that's used to avoid a guardianship setting. It's a little different than a guardianship. Remember, in a guardianship, we said the court takes rights away from you and gives them to someone else who is your guardian. A power of attorney is different. It's a document that's created by you while you're alive and while you have full capacity to understand what you're doing. And instead of you losing rights with a power of attorney, you grant somebody else the same rights that you have, and that person is called your agent. And so there are two types. You can do a power of attorney that deals with your finances and your property, in other words, your money, your stuff. And you can separately do a power of attorney that deals with your health care. You can't have one power of attorney accomplish all of that. Under the statutes in Wisconsin, they're two separate documents. But you grant an agent the right to speak for you. Now, an interesting thing about powers of attorney that's different than a guardianship, and this is one of the reasons doing them is, in addition to avoiding a guardianship proceeding, one of the reasons that doing a power of attorney is really useful and a good thing is just because you grant somebody the authority to speak for you doesn't necessarily mean you lose the right to speak for yourself. In fact, with the power of attorney by law, your agent who you've appointed has to consult with you about the decisions that they make and has to take into account your wishes and desires before they take any action on your behalf. Now, you may be incapacitated, but you could be incapacitated to a wide degree. There's a lot of latitude in there. And there may be times where you really understand what's going on when your agent is talking to you. And you will be able to intelligently sort of tell them what your wishes are. And your agent has to take those into account. They can't just freeze you out. So that's a really powerful thing to have. The other thing is that you have the right, unlike with a guardianship, you have the right to revoke a power of attorney. In fact, you can turn them on and turn them off, and some people do that throughout their lives. If you decide you don't like what's happening, you can revoke your agent's authority. You can grant it provisionally. One example of that deals with, if you're traveling and you're going to be out of the country for months on end, you can give someone authority to act while you're gone in case something goes wrong and you're going to be in a situation where, you just can't deal with a house fire or a break-in or a big issue that comes up with one of your financial institutions. You can empower someone to step in and deal with those things for you while you're gone. And then when you come back, you can revoke it and take their place. That's a unique use of powers of attorney, but it's one that's very, very useful in some situations. So powers of attorney are very useful documents. They're not, I don't want to say they're simple documents, but they're not terribly complex to put together. And they're fairly easy for you to sign and set forth. And for most powers of attorney, there's really sort of two varieties of them. One is the power of attorney where you give someone authority right then. You sign on the dotted line, May 18th, 2021. I sign my name, James F. Guckenberg, and it's activated as soon as I sign it. And my agent can go off and take action relying on it, right? There's a second time that's called a springing power of attorney, which is more popular. With a springing power of attorney, the way it works is if the power of attorney provides that unless a doctor, or in the case of a healthcare power of attorney, two doctors or a doctor and a psychiatrist, unless a medical professional makes a determination that you are incapacitated, then the power of attorney is not what we call active. The agent can't act under it. In a classic way that this goes, and being at the medical college, I'm sure some of you have probably seen this. A doctor will fill out a form. It'll get signed off by a second doctor, basically saying that the person is incapacitated and doesn't understand what's going on. That form then gets stapled to the power of attorney document or scanned in with it or attached to it. And once that happens, the document is activated and the agent can take action. That's the case with a springing power of attorney. And with healthcare powers of attorney, they're all basically springing. Financial powers of attorney need not be springing, like for the situation we talked about, where you're going to be, for example, out of the country and away from your assets for a long period of time. So those are powers of attorney, a very powerful estate planning tool. Another one, this one is less common. People don't often come to me and ask me about beneficiary designation, but it's a very important one. Beneficiary designation. So now we're jumping into the world where you have passed away, right? All of your financial accounts, bank accounts, life insurance, retirement accounts, stock accounts, they all have the opportunity to name a beneficiary of those assets when you pass away. The easiest one to understand is life insurance, right? You've heard of people being a beneficiary of a life insurance policy. When you take a policy out, you're asked who you'd like to make the beneficiary of the policy. Often it's a spouse or a child. And so when you die, those funds will pass directly to your beneficiary once a claim is made, without probate. They'll pass fairly quickly. Usually takes a death certificate showing that you're deceased, and then the beneficiary has to prove who they are, and then very quickly those funds will get paid out. And it's a very powerful tool because for many of us, most of what we own now is tied up in different accounts, whether it's a 401k or a 503b or some other sort of pre-tax retirement account set up by an employer, or it's life insurance or an annuity or savings accounts. All of those places have the opportunity to designate someone to receive those funds when you pass away. In fact, now, once I explain this, I do get a certain percentage of estate planning clients who come in and they say, you know what? I think I don't have that many assets. I've only got 3 accounts. I rent my house. And I'll just use beneficiary designations. And they decide they don't really need much of a plan. Now that's a good fit for some and perhaps not for others, but it does work to a certain degree. So they're very powerful. If you go to the bank and you say, I want to do my beneficiary designation, there's another name that the bank probably uses, which is called a transfer on death document or a transfer on death designation. Those forms come by slightly different titles, but they all accomplish the same thing. And in fact, even with my estate planning clients who do very complex estate plans, I tell them beneficiary designations are sort of like the initial inroad to getting assets going in the direction that you want them to go. You gotta go and fill those out. So I'm always preaching to them about doing that. Even with a house, the state of Wisconsin has what's called a transfer on death designation for real estate that can be filled out. It looks like a deed, and you can prepare that. It gets recorded with the Register of Deeds, just like the deed to a house. And if that's done and it's done properly, then when you pass away, you can name someone or a trust to receive your house upon your death, and ownership will transfer without probate. Houses are one of the biggest triggers for probate, because people will go to their banks and all their financial institutions and do their designations, but they don't think about their house. And at some point, someone will want to transfer that house, and they won't be able to do it if it hasn't been dealt with while you're alive with a beneficiary designation or putting it into a trust or something like that. So very powerful tools for estate planning that don't often get a lot of talking about. One that most people have heard about, this is sort of the twin brother or sister of wills. When people call in, they either ask they need to set up their will or they need to set up a trust. And so for many of us, that's what we think about when we think of estate planning. And trusts are very, very useful tools for avoiding probate. They can function in a number of different ways. And so let's sort of unwrap it and talk about what they are. There are 2 kinds of trusts. One is what's called a revocable trust. It's a revocable living trust. It's a trust that you set up either alone or with a spouse while you're alive, and you reserve the right to change it or to revoke it at any time. You name yourself the trustee of the trust. You have control over it. And so that's something that's all yours, that you can kind of do whatever you want with. And then usually when you pass away, there's a provision that says, once I die or once my spouse and I pass away, then the terms of this trust can't be changed anymore. That's a revocable trust, living revocable trust. The other type of trust is what's called an irrevocable trust. And that is a trust that once you set it up, there is no opportunity to change it anymore. You set it up, you set the ground rules, and you appoint whoever is going to be the trustee, whether that's yourself or someone else or someone who's going to succeed you. And they have to follow the rules of the trust, and they have to follow them to the T. They can't really change them anymore. And irrevocable trusts have a really good place, and they can be very useful for specific things. We're going to talk about that just a little bit. But by far, the vast majority of estate planning for people who are, not dealing with issues like Medicaid and those kinds of things, or special needs issues, for people who are not dealing with those issues, revocable trusts are by far the most popular ones that are used. Now let's just get down to some nitty gritty details about what exactly is a trust, right? So a trust really is, it's just a set of directions written on paper. It's an agreement. All trusts say that they're an agreement. And it's an agreement between you as what's called either the grantor or the settlor in Wisconsin. In Wisconsin, we usually call them settlers, but sometimes they're called grantors. It's you who's creating this trust as the settler or the grantor. You're agreeing with yourself, essentially, that you're going to create this trust. It's a hereby created and put into existence. And the purpose that you're creating it for is to hold assets while you're alive and any assets that come to it after your death. And that's really all that the purpose of the trust is. It's to hold assets and, of course, distribute them, right? And so you, as part of that, the set of directions will appoint a trustee for the trust, someone who oversees the trust. That's usually you or a spouse. And often then another family member or a trusted friend, sometimes a bank, will serve as a backup trustee to oversee the trust. And so then the trust will set forth what happens to assets that are inside the trust. And we'll get to how do you get assets inside a trust. But let's talk about the mechanics a little bit more. The trust will often say, anything that's in here, I can do with as I want. I can take out assets. I can put them in. I can take part of them. If the assets earn money, I can take that money for myself. And then they often will say, when I die, the assets in the trust pass to, and then you would name a beneficiary. Often it's a spouse if you have a spouse. And if you and your spouse are passed away, then often it's your children, but it can be any people or even an organization. And then there'll be provisions that say, once all the assets are paid out according to the terms of the trust, then the trust is terminated at that point in time. But let's talk a little bit about how this works practically speaking for estate planning. If we go back to, we're going to use two examples. One is the house and one is the bank account, right, with the beneficiary designation. So let's use bank account first. So with your bank account, rather than name a spouse or a child or somebody, you can identify the name of a trust. And so if I am Jim Guckenberg and I have created the Jim Guckenberg Revocable Trust, I can go to my checking account and savings account, and I can designate my trust as the recipient of the money in those accounts upon my death. And then when I pass away, the person who's appointed trustee can bring a death certificate to the bank, prove that I've passed away, and the bank will write a check to the trustee for whatever amount of money I have in my accounts. And so let's say the trustee is holding a check with a couple of $1,000s in it. And the check will be made out to the trustee as trustee of my trust, of the Jim Guckenberg Revocable Trust. And so they'll have this check. The trustee can then take that check, go across the bank or just deal with the same bank, and open up a bank account in the name of the trust. Okay. And at that point in time, the trustee opens the account for the trust. A trust can have a bank account, and then we'll deposit that $2,000 into the trust's bank account. And now the Jim Guckenberg Revocable Trust has some assets. It has $2,000 sitting in it in a bank account for the trust that can be paid out to beneficiaries according to the terms of the trust. And so if you think of all of your different assets that you have at financial institutions, whether they're a retirement account or a stock account or a bank account or life insurance, you can pass all of those assets to a trust where you have set up specific instructions as to how those assets will get paid out. And that all can happen around the probate court. There's no need for the probate court to get involved. So it's a very clean way to move assets once you're deceased through a vehicle where you can specify what should happen to those assets. And depending on the size of your estate and what you're dealing with, if you have minor kids or you have grandkids that you want to provide for that are minors, the trust can contain provisions that say, okay, while my grandkids are under the age of 25, if they need something for health, maintenance, education, and support, and they don't have other resources, trustee, you can give them some money, whether it's, you know, if they need books for college or they want to go to camp or something like that, that's a good thing for them. You know, you can authorize that payment, and trustee, you can pay it directly to whoever is getting the money, or you can run it through the child's guardian, or you can, if the child's old enough, you can give it to the child. So you can build in a lot of flexibility, but it allows you to pass your estate through in ways that you can kind of set up how people are going to receive these funds. In many cases, it's used just to avoid probate, and if you have adult kids, the assets are just paid out to the adult kids, and then they deal with them. But if you have kids that are younger, like I said, grandkids, the trust is a very good way to handle that kind of thing. So that's using a revocable trust, using beneficiary designations that are designated for a trust, right? And that will bring you right past the probate court and act as a conduit for your beneficiaries. Let's talk about the situation with a house in a trust. You can do the same thing with a house. Remember, we talked about before, there's a transfer on death designation for a house. And so when you would pass away, if you prepared that designation, your house would then transfer ownership to your trust, where you can give instructions as to what should happen with it. Maybe a family member gets to live there while they're alive. Maybe it gets sold right away and the proceeds distributed. But you can do the same thing with your house. Now, trusts have another provision or another sort of mechanism that can be used, as opposed to using beneficiary designations to send money to a trust upon your death. You can put assets into a trust while you are alive, and the house is a really good way to illustrate that. Instead of doing a transfer on death designation for your house, so that your house transfers upon your death to the trust, you can, while you're alive, transfer ownership of the house to the trust right while you're alive. In other words, you can, it's called a quitclaim deed. You fill it out. You say, I'm the owner of this house. I'm the grantor of this property, and I am hereby transferring title to my house to my revocable trust, to the James Guckenberg Revocable Trust. And you prepare that deed. It gets recorded with the Register of Deeds, and now the trust, while you're alive, has assets that it owns. It owns a house. You can do the same thing with a savings account or a checking account. You can close your current checking account down in your current savings account, and you can reopen one for the trust, where the trust now owns this bank and checking account, and your money is sitting in that trust while you're alive. So a lot of people will ask, well, why would I do that? In my experience, many people wouldn't, because if they have a house and they want to own it in their own name, they have a checking account or a savings account, they want their name on it. They don't want their trust's name on it so that they're writing checks from their trust. But it can be useful when you get to the point in life where you find that you're really needing help from your family to manage your affairs. you can put your assets into that trust while you're alive. You effectively, in your name, own nothing or very little. It's all in the name of your trust. You still have full control over it. For tax purposes, everything passes through to you, so you file taxes basically the same way. Nothing changes that way. The difference is when you pass away, you don't own those assets, your trust owned them. You got to use them freely, as if they were yours, right? And they really were yours because they were in your trust. But when you pass away, there's no need to go to a bank to enforce a beneficiary designation. And there's no need to, when you transfer a house with a beneficiary designation, there's a little bit of forms that have to be filled out. There's no need to do that. Your trust is just there. The assets are still there, and your successor trustee can manage them and distribute them, to the next group of beneficiaries in line in your trust. So it's a very useful thing. And for families who have done that as part of their estate plan, and then they make sure that everything's done properly, they're very thankful because there really was almost no administration for them to do when they're often it's parents who have passed away and there are adult children dealing with the estate. There's really nothing for them to do because those assets are all sitting in a trust. It's not one that a lot of people use, but it can be very, very helpful to your family when you're getting, like I said, to the point where you're just really not able to manage your affairs. It kind of takes some of the pressure off of a power of attorney agent because they would be dealing with your individual assets and not your trust. Your trustee would deal with those. So it can be helpful in that way too. Now let's just talk about some pitfalls with using trusts a little bit. One of the big ones that comes across my desk is, and this is actually in the probate context, is a family will come in and they'll say, my parents are both deceased. They did this elaborate estate plan a decade ago, and they spent a lot of time and money on it, and we've all had copies of it. We took the trust to all their accounts for their retirement, to the bank, everywhere, and nobody will honor this trust. What's wrong with it? What happened here? 9 times out of 10, and I'm going to just click backwards here a little bit, it's the beneficiary designations. The trust wasn't funded with assets while the husband and wife were alive. So the only way assets were going to get there was for them to do their beneficiary designations and name the trust. But they never did that step, which is why my clients roll their eyes at me and get sick and tired of me talking about beneficiary designations. But that's why those are so critical. Because families will come in and I'll say, yeah, you're going to have to go to probate court. Your parents never told the bank, pay the money to my trust when I die. They didn't do that with their house. They didn't do that with their retirement accounts. So all of their assets are now probate assets because they haven't identified either a trust or a person to get the assets when they die. So it's going to go through probate. So for a trust to work, it has to get funded. You have to either designate your assets as being paid to the trust when you die, or while you're alive, you have to put those assets into the trust so that the trust has some funds. I want to be cognizant of our time here, and I'm spending a lot of time on trusts because they're one of the things that people think about really the most. I want to just touch a little bit on what we talked about earlier as irrevocable trusts. Those really get used, like I said, in kind of two concepts or sort of two areas. And they both more often than not deal with becoming eligible to receive benefits, whether that's Medicaid benefits. Situations where people are quite elderly and they're going to be going into a nursing home and they're trying to set up their estate so not all of it is used to pay those nursing home expenses or medical expenses, or a situation where someone is disabled and they need to qualify for disability payments. And so very often that's where those trusts come in, because in order to qualify for Medicaid or disability, if you have a trust that has assets in it, you can have no control over those assets. You have to essentially sort of give all the assets away to this trust. And the trust has to be set up so that the trustee is only allowed to give you assets in the event it won't disqualify you from receiving your benefits. Otherwise, those assets will be used and counted toward your income, and they'll be spent down before you receive disability benefits or Medicaid. So they're very specialized trusts, and they are used in very particular ways, and there are very particular rules around how they get used. In fact, I could do it, and they do day seminars just on understanding how those works and the ins and outs. I think the thing for us to know here in terms of just a basic estate planning seminar is to make sure you understand that setting up a revocable trust that you have control over is not going to help with the Medicaid kind of planning or long-term care planning. It's an irrevocable trust, and there are very specific rules about how to deal with those. So let's move on a bit. Sort of one of the last ones I'm going to talk about is called a marital property will substitute agreement. There's a lot there, right? But it's a fairly simple concept. We've probably all heard of what's called the prenuptial agreement, right? The lawyers, we call them marital property agreements because they come under the Marital Property Act. That's really not what this is, but the Marital Property Act allows married couples to enter into a marital property agreement to give certain property to each other without going through probate. Even if you didn't do the beneficiary designation or you haven't put it in a trust, if you have this marital property, quote unquote, will substitute agreement, and you designate your assets for your spouse, even if you haven't done any other estate planning, they will transfer without probate to your spouse. And upon the death of your spouse, you can then transfer them into a revocable trust, again, without having to go through probate. It's a really powerful aspect of the Wisconsin Marital Property Act that specifically says spouses can do this. And the reason a bank or a life insurance company or a title company will allow you to make those transfers, even if you didn't do the transfer on death or beneficiary designation, is because the Wisconsin statutes specifically say that you are allowed to do this. And so they breathe a sort of a sigh of relief. They say, no, it says right there in the law they can do this. If someone, they're always worried. The big worry for them is that someone's going to come and challenge them, right? That they're going to get themselves into trouble and they're going to have to, pay extra money. They want to avoid that at all costs. But when they see that the statutes say specifically that spouses can enter into this kind of agreement, then they rest a little more easily, and they're willing to pay the money out for the most part. They are fairly successful. I think the thing to know, just as a note of wisdom here, is that all the financial institutions that you or I or whoever deals with in their lives, they all have their own procedures for how they treat these documents when they're presented to them. And we don't have a lot of control over that. For the most part, they will honor, beneficiary designations, and these will substitute agreements. And if those assets are in a trust, they will honor that. But there always can be some problems along the way. There's sort of no guaranteed way, but it's sort of an 80-90%, this is going to be fine, we should rely on this with a lot of these documents. And a marital property will substitute agreement is a very useful tool for spouses to be able to do that. I often look at it as sort of a safety catch. If you're doing wills and you're doing a trust and you have an asset that you just forgot to name the beneficiary designation on, you don't want to go through your will and probate, the marital property agreement can sort of act as sort of a buffer, right? It can sort of be a stopgap, like, well, we missed an asset here in our estate plan, but we've got this will substitute agreement. It says pass it without probate, and so we can do that. So very useful tools there. Just a note about what's called a testamentary trust. That is a trust that's inside a will. It comes to life when you pass away, And when your will goes through probate, the court overseeing the probate will then bring the testamentary trust to life, will appoint the trustee themselves, and will make sure that assets that are supposed to go into that trust go into it and that it's administered properly. But that is not a trust that works to avoid probate. That is a trust that is set up to be created in probate. So sometimes there's a lot of confusion about that. Testamentary trust, last will and testament, not for avoiding probate. And then I wanted to talk about medical directives just briefly. Excuse me, before I want to just pull a note up here for myself. Okay, yeah. So medical directives, I got medical college, the folks that organized said specifically that they wanted to touch upon these, and I'm trying to leave some time for questions here, but medical directives come under what are called in the law, the topic of advance directives. And that really sort of deals with three kinds of directives. One is the declaration to healthcare professionals, which allows you, an individual who's an adult and is competent, to prepare a document authorizing withholding of life-sustaining procedures or feeding tubes if you have a terminal condition or you're in a persistent vegetative state. This is you specifically giving authorization to your medical providers to do this withholding. And the only time that they wouldn't follow it is if it would cause pain or reduce comfort, or it's what I'm sure many of you have heard about, is it's medically contraindicated. Now, there's a lot to unwrap with those two, and we're not going to go that deep into them. But there are some exceptions to them. Medical directives are a little bit like healthcare powers of attorney, in that a healthcare power of attorney can also authorize the withholding of these procedures. The difference is, with a medical power of attorney or healthcare power of attorney, you authorize your agent to say, withhold these treatments. In a declaration to healthcare professionals, you yourself are giving the authorization. I mean, it's kind of a bit of gray area there. And often when I draft a medical power of attorney or a healthcare power of attorney, I give the agent the authority to do these things. So they accomplish the same thing, just within a different pathway. The other one to know about that I'm sure we've heard about is what's called the do not resuscitate order. That's an order given by a physician after you give consent. However, you should know that very often a guardian or a healthcare agent can request the do not resuscitate order. So if you become incapacitated, your guardian can still request that if you give them the authority to do that, or if they're given the authority by the court. And then the last one that falls under advance directives is a final disposition, which is a document in which you can authorize what should happen with your remains, everything from funeral to burial, et cetera, et cetera. So another good thing to be aware of as part of an estate plan. So let's talk briefly about next steps, and then we'll go into some questions. First thing you want to do is understand your goals, needs, and assets. That's why I gave you that workbook. It's a good way to just do an initial inventory and get you thinking about sort of what kind of a plan do you want and what do you have to take care of. Some people, it opens their eyes just in terms of what they have in terms of assets. Next would be check your beneficiary designations. Make sure they say what you want them to say. Keep copies of them in your home. Keep them someplace safe. If you keep copies of your beneficiary designations someplace safe in your home, and you tell your family where they are if you pass away, then your family has a roadmap to what your assets are. They don't have to try to figure it out. They often have a phone number that they can call. Decide what plan works for you. Remember, we said earlier, some people just rely on beneficiary designations. Others rely on very complex trusts. It all depends on sort of what your tolerance for these things are, what kind of assets you have, and what you want to accomplish. And then take action. I've practiced, several different areas of law. I can tell you that when someone is being sued, they will find an attorney very quickly. When they are thinking about doing estate planning, that's more something that sort of just is something that gets brought up and talked about over years. And unfortunately, sometimes it never actually gets done. And so then you have a family that's going through a probate court because no one took action. So set a date, find a time that you're gonna start looking into it. If you're gonna use an attorney, give that person a call. And then last thing I would say, what value can an attorney add? There's lots of free estate planning resources out there. I think the value that I add is, number one, what you got here in terms of just raw data and information. And then an attorney will go through the documents, explain them to you, make sure that they're signed properly so that they're enforceable and they do what they're supposed to do. Spending money on an attorney to do an estate plan, probably a little bit less than a probate, but usually money well spent. And I see that my time is up and I finished right on time. Thank you.
Fantastic. Thanks, Jim. A lot of good information, which of course has prompted some questions for us. So can a will that was established outside of Wisconsin be used in Wisconsin?
Great question. Yes. The two requirements are, number one, it has to have been a valid will in the state where it was established. So if you got one in Montana, if it was valid under Montana law, Wisconsin will interpret it. And then number two is it can't authorize doing anything that Wisconsin law doesn't allow. So sometimes Wisconsin will carve out parts of a will if they're not allowed under Wisconsin law. But yes, it can be used in Wisconsin.
And if you have a will that involve going to probate court before all those named in the will can get the property?
Yes. One of the last things that happens when a will goes through probate court is people who are named in the will get the property. That's toward the end, unfortunately, of the process, because creditors have to get paid off, other expenses have to get paid, there has to be an accounting. And so people who are waiting for distributions under a will, that's usually one of the last things that happens.
And where do you get a transfer on death designation for a house, and where does it get filed?
You can do a Google search, which I often do a Google search for it, transfer on death designation for house or property. I do that to make sure that I'm up to date with the latest state of Wisconsin forms. So they're readily available for free online. And they get filed with the Register of Deeds. It costs $30 to record the document, $35 if you do it electronically.
And if a friend is the alternate trustee on a revocable trust, is the non-related trustee taxed on the assets after death?
Not personally. Any tax that is levied on a trust is generally after you pass away, and it's on income that the trust earns. And so the trustee wouldn't personally pay those taxes. It would be assets from the trust. And if the trust didn't have money to pay the taxes, then the trust would deal with it, not the personal trustee. It'd be the trustee that would have to do the work to get it paid and taken care of, but it's not their personal assets.
And you mentioned wills and trusts. Which would you recommend, a will or a trust or both?
Well, it's a good question and it's a complicated one. I'll be honest with you. It depends on you and your family. Some families that I've come across, they just don't get along and there's so little trust in them, between them, that I have said to people, and people are so concerned. I've said, you might just think about doing a will and letting the probate court oversee this if you really think there's going to be real problems there. And occasionally people will do that. They'll say, yeah, we should probably just do that. If that's not the case, I'm a fan of having a trust to pass things around probate, but having a will in case you miss an asset with your trust. So I usually recommend both.
Okay. And will you work with clients remotely to set up a trust?
Yes, in fact, since March of last year, I've been almost entirely remote. The one exception is that the state of Wisconsin has not allowed estate planning documents to be signed remotely. They're like one of the very few exceptions today wills and trusts and things like that have to be signed in person. So we do everything remotely. Takes about 3 or 4 meetings. And then the last meeting is actually in our office where we're masked and we sign in front of witnesses. And that's usually, 15 to 30 minutes of time in most cases. And we do Zoom in or phone, either one.
So does a will always go to probate?
Yes, if someone's going to try to enforce it, it will have to go to probate. There's no way to get anything through a will without going through probate. Having said that, some people who have a will, who set up their estate plan to avoid probate, do it well, and there's no probate necessary, and the will never sees a probate proceeding. The law does say that within 30 days of dying, if you know the person has a will, it's supposed to be filed with the register and probate. But that's usually the end of it if you've done a good job of probate avoidance.
And based on your comment during the presentation, is it safe to assume that these trust laws are fairly state specific?
I think that's right. There are laws, interstate, acts where states kind of agree on a model law and they maybe modify it a bit. So there's some attempt to have those things consistent from state to state. In Wisconsin, a trust from another state will be enforceable, sort of like with a will. If it was valid there and it doesn't break the law here, then it's pretty much going to be enforceable. The advice I give my clients is if you move to a different state, just spend a little bit of assets of your money to try to have an attorney review it and just tell you if, this is a big problem in our state. So you get that. And I can give you an example that just came up. I'm reviewing a trust that's a Wisconsin trust. I'm revising it because in Florida, they only want living people to be trustees. Not that you can't name a bank, but they much prefer living people. And this trust used a bank as a trustee. And so these people moved to Florida and they're revising their trust to name a person as their trustee so they don't go in and run into any problems. Those kind of things can come up. So you should have a looked at it.
And if all assets, including a house, have beneficiaries, why would I want a trust?
Like I said, you may not need one. You could, as long as you keep up with them and you're comfortable, with who you've named, and it's not like minor kids where you're concerned about them having those assets, that can be a fine estate plan that works. You just have to maintain it. So if you change houses or change accounts, more work has to be done.
And what is the cost, maybe a range, to set up a trust?
So it varies from attorney to attorney. I can tell you my plans are usually between $500 and $1,500, depending on what you do. Most of my clients don't have to deal with estate tax planning, and so my plans are not as complex as others because my practice is just sort of focused around that. If you're going to hit the estate tax level, which is $11.5 million in assets if you're single and 25 million if you're married, then you're going to have a more complex plan. It could cost you $5,000. Some people pay, much more than that, depending on the amount of assets they have and what they need to get done.
And I think we had a similar question before, but maybe just a different twist. How does a will fit into estate planning if going to probate still is part of the process?
Yeah, so the will is your chance to control what happens in the probate court. I'll just very quickly, if you don't have a will and you don't name somebody, there's a law that says first it goes to your spouse, then to your kids, then to your siblings, then to your parents, then to your siblings, and it radiates out through your family tree. If your spouse is gone and you don't have kids and you don't want it to go to your parents or your siblings, your will is your chance to designate somebody else. So that's where it's useful. It's really only useful in that probate court situation. And if you have to set up a trust or something like that, it gives you control over what happens with your assets when they get distributed in probate court.
And what is guidance for the compensation of a trustee? what fees can one expect from a bank, for example, or a relative?
Yeah, so they have to be reasonable fees under the circumstances. So depending on the type of trust and the amount of assets, some banks will charge a percentage annually. They may charge based on income or the trust assets. Some banks will charge hourly only if they're doing the work. A family member, in my experience, they tend not to charge. They're entitled to it by law, trustees. But they tend not to unless and until they get in a situation where every month they're paying some bills, or 5 years in a row they're doing tax returns. As the tasks of administering kind of go on over time, then they'll start to charge maybe 10, 15 bucks an hour for 2 or 3 hours worth of work for the trust. They have to keep track of it and report it to the beneficiaries. And for some people, they just don't want to do it, but they tend to pay themselves as time goes on. You can't pay yourself like an attorney if you're not an attorney and you're not doing the legal work for the trust. You can't pay yourself like a tax preparer if you're not preparing the taxes for the trust and you're an accountant. So it depends on your skill level and the kind of work you're doing.
And I think I got all the questions. I don't know, Mark, did you see any other ones in there that I may have missed? I don't want to miss anybody's questions.
No, I don't. It looks like you covered them all. The only thing I would mention also, being the kind of the 403B person from MCW, is make sure you have a beneficiary on your retirement account. So the will is good for for probating and designating maybe physical assets, your car or your house, but your money from your retirement account isn't going to go to the will. It's going to go to your beneficiary. And if you don't have a beneficiary, the retirement plan is going to say who it gets paid to. Your will is going to have nothing to do with it.
Interesting.
And I do see another question here. Does having a house in a trust shelter it from creditors or lawsuits?
It does not. The trust is a great tool for estate planning. It is not a great tool for creditor protection as a general rule. However, there's a big however. Once you pass away, if you have what's called a spendthrift provision in your trust for your beneficiaries, you can basically provide that no money will be paid out to a creditor of a beneficiary. And the way that works is I use college kids as my example. Sorry, college kids, if there's any of you out there. You go to college, you run up $2,500 on Capital One, and Capital One takes a judgment against you, and the trustee knows you're supposed to get a distribution of money, and they also know that as soon as you get it, Capital One's going to come and take it from you. A spendthrift provision says if the trustee knows there's a creditor after you, they don't have to give you the money that they're required to give you. They can wait until the creditor is satisfied and paid off and gone. In the meantime, if you need money for tuition, they can pay the money right to the bookstore. They just won't give it to you or to the college kid. So that goes around the college kid until the threat of collection is gone. So that's one way that it can work. But as far as like a foreclosure on a mortgage or a debt of yours for you and your trust, it's usually not an effective way of avoiding that. The best ways are sort of, I hate to say, is not to get into that situation, because the law is set up so that people really can't transfer assets away from creditors very well. They try. Sometimes they're successful.
And can we do estate planning for foreign land investment?
You can. If you're going to own property in a foreign country and you want to include it in your estate plan, you really need to get an attorney either from that country or an attorney in the United States who knows and deals with that country's laws very well, because foreign countries have different rules. There are some countries that say if you own land, it goes to your father's family, and that's it. You can do what you want with the rest of it, but it goes to a spouse or a brother or a dad. I believe it's France says that a certain percentage of your estate right off the top before anything else happens, it goes either to your spouse or your kids, one of the two, and you have no control over that. You can just control what's left. So you need to know what the foreign country is going to do with the property. It's very important.
And I think this is the last one. I think I'm caught up. I apologize if I missed any. Is POD a valuable tool to enable your heirs to inherit bank account assets quickly?
Yes. So payable on death is that beneficiary designation or transfer on death document. I didn't say POD, so thanks for bringing that up. It's the same kind of document. If you put them down as the POD on a checking account, they just need to show that you've passed away and that they are who they are, and they're the recipient, and very quickly the assets will get paid out.
Okay, I think I've gotten them all. I apologize if I missed anything. You can always email me, or you can email, wellness@mcw.edu or retirement@mcw.edu. If you have additional questions for Jim or want, contact information for Jim, please, don't hesitate to let us know and we'll help guide you. And we appreciate your time this afternoon. And thank you so much, Jim, for the session. It was extremely helpful.
Good,
We
thank
covered
you.
a lot of ground.
Well, good. I hope everybody got something out of it, and it's a pleasure to be presenting again. So thank you very much.
Thanks so much, everyone. Have a good evening.
Bye now.